Good morning, everyone. As just mentioned, my name is Alex Walton. I'm with the North Carolina Attorney General's Office in what's called the Tort Claims Section. I'm here today with my boss, Ms. Melody Hairston. We are both special deputies, although she's my boss, and I don't get to carry a gun or a badge. I just have a cool title, so that's why they call me a special deputy. At the outset, I just have to note from a personal standpoint that this room, the room that we're in right now, brings back kind of mixed memories for me. I went to North Carolina State. I'm a big NC State fan. Go Pack, even though we got our tails kicked this weekend by those people from Chapel Hill. But in the same vein, this room was where I took part of the bar exam, and I have not been back here since then. So while it conjures up some good memories, it also brings back some absolute nightmares for me. So I'm going to be talking a little bit today about what are called state tort claims, and then Melody is going to be talking about lawsuits against individual employees. Just by a show of hands, just out of curiosity, who here has heard of the term state tort claim before? Anybody? Okay, that's a lot of people. All right, very good. As I was looking out over the crowd before we got started today, I didn't see many faces that I recognized. So consider yourself fortunate because typically if you meet me or we have an opportunity to work together, it's because something has gone wrong or potentially went wrong and there's a lawsuit involved. I always tell folks after I meet with them or after a case is over that my hope is that we never have to meet again. And so hopefully, and this is no disrespect to anyone here, but my hope is that aside from today or any generalized questions that y'all may have, we never have to meet in the future. So at the outset, like I mentioned, I'm going to be talking about state tort claims. And just so that everyone is on the same page, because a lot of times lawyers like to use big words or make up words to make us sound or feel more important. A state tort claim, what that actually refers to is a lawsuit. It's just a fancy name for a lawsuit that's been filed against a state agency on the basis of negligence. I'll go through a little bit more in detail what a negligence claim is, but generally what these claims are, these state tort claims, are lawsuits filed against an agency seeking monetary damages, not breach of contract actions, not constitutional claims, but kind of the things that you think about if you would think about, for example, a personal injury lawsuit or a property damage lawsuit. Now, one of the questions that we get pretty frequently is the difference between claims against the individual versus claims against the agencies. And I'm going to be using some general hypotheticals here. I understand that we have people from various state agencies, and so I may be using some of those state agencies as examples. I'm not talking about any specific state agency or any specific case that I've handled before, although we are an equal opportunity employer and we do get cases from every agency. But to describe or to elaborate on this idea of the agency versus the individual, instead of starting off with a state agency, I thought I'd start off with a situation involving this UPS truck here. So a lot of the cases, or a big chunk of the cases that we get into our section, the Tort Claims Section of the Attorney General's Office, are motor vehicle accidents. It's kind of our bread and butter. We get a lot of these. And so in this situation, by way of example, let's just say that Jane, the driver, the regular motorist, was struck by this UPS truck. Jane, the driver, has basically three ways that she can pursue legal recourse in this particular situation. If she believes that, for example, the UPS driver ran a red light and he was the cause of the accident, she's the reason that she got hurt, Jane, the driver, can do three different things. The first is she can sue the individual driver, meaning Jane, the driver, can sue Joe, the UPS delivery man, in what's called his individual capacity. Melody's going to be talking more about those cases involving individual capacity claims, but if she wanted to, she could sue Joe, the delivery man, for his assets or his personal property. What Jane could also do is sue UPS, the company. And that is because, assuming that, and I'll talk a little bit about this in a second, but assuming Joe was on the clock, the agency can be held responsible for his actions. And then the third option is she can sue both the agency, she can sue UPS, or she could sue the individual driver. Now, the majority of cases that we see in the Tort Claims Section of the Attorney General's office are against the agencies. We do have occasional cases where individual employees are sued, but by and large, that is a very, very small percentage of our cases. And there's a pretty simple reason why that is. It's all about the money. I mean, I hate to be crass, but typically the folks who are suing us and the plaintiff's attorneys who are suing us are going to take advantage of the most effective way to receive monetary compensation. And so you're not going to go against an individual driver, for example, who may only make $40,000 a year, versus a multi-billion-dollar company like UPS with large insurance policies, who you know is going to pay on that. You can sue Joe the delivery man, that's fine. But if Joe the delivery man doesn't have a nickel to pay you, then your $1 million judgment or order is really no good. He's what's called judgment proof. So typically, any plaintiff's attorney worth his salt will file a claim against an agency, and again, that's where the majority of cases that we get. Now, in addition to the money, suing the agency also allows for multiple kind of ways in which you can sue an agency, and an agency can be held responsible. Again, it makes it more likely that they can recover. So, going back to our UPS example, let's just say that Jane the driver sues Joe the delivery man. She can only sue Joe the delivery man based on one cause of action. The cause of action is basically the factual basis in which you bring a lawsuit. And that is Joe the driver, Joe the delivery man, didn't drive his car in the correct way. He drove it negligently. Whereas if you sue the agency, you can kind of throw a bunch of stuff at the wall and see what sticks. For example, you can sue for the actions of Joe the delivery man because he's an agent, he's responsible, or the company is responsible for his actions. You could sue UPS, or you could sue the delivery man's manager because the manager didn't properly train him on how to drive that van. You could sue the mechanics for UPS because, let's say, the brakes didn't work. Essentially, what it allows is more opportunities or more avenues to recover. And so if you're given that option, if a plaintiff's attorney is given that option, they're going to go with whatever gives them the best opportunity to recover. And then last, the process as it relates to specifically state agencies and state tort claims is a fairly simple one. There's a policy or there's a statute that kind of lays out how the whole thing works. There's specific rules that apply, and it's a pretty straightforward process. And so it's pretty common that we see cases against the agency or versus the individual. We were talking briefly yesterday, and I think we came to the conclusion that less than 5%, maybe even closer to 2 to 1% of the cases that get filed related to state agencies or negligent state acts are against individuals versus the vast majority against the agency. So going back to how agencies can be held responsible for the acts of their employees, the legal doctrine here is called respondeat superior. And in Latin, what that means is let the answer master. And stated another way, the rule says the master-servant rule. I don't know if anyone here has ever seen the show The Office. I'm a big fan. But there's an episode where Michael Scott is pulling into the parking lot, and he's on the clock, so to speak, and he runs over another employee with his car. And his quote is, it's a mockumentary or whatever, and he says, "Guess what? I have flaws. What are they? Oh, I don't know. I sing in the shower, sometimes I spend too much time volunteering, and occasionally I hit people with my car. So sue me. And then he quickly retracts that. Here, Dunder Mifflin can be held responsible for the actions of Michael Scott in hitting another coworker with his car because of this idea of respondeat superior, where the agency is responsible for the actions of the individual agents. You know, an entity like the Department of Transportation or the Department of Health and Human Services, that entity, that kind of abstract thought, can't really commit a negligent act. It has to be based on an individual's actions or inactions. Now, it wasn't always the case that you could sue the state, believe it or not. We're going to have a little bit of a history lesson here. You guys are probably in for more than you bargained for this morning. But once upon a time, the state, the government, enjoyed what's called absolute sovereign immunity. And what that legal theory said was that you could not sue the government on any basis for any wrongdoing, no matter how egregious the conduct. And this principle is based on this idea of what's called the sovereign. And this actually goes back even further. Here's a picture of LeBron James. He's the current king. This concept of the sovereign goes back to the English monarch. So our law here in the United States is based on British law. And British law is based on what's called English common law. And English common law goes all the way back hundreds and hundreds of years, and it goes back to the idea that the king was ultimately in charge of making all of the laws. He was the one that got to set policy, procedure, laws, all of those sorts of things. And because they believed that the monarch, the sovereign, was appointed by God, he could do no wrong. Because he was an agent of God, he could do no wrong. Now, over time, that's obviously changed. And as we know, no one is infallible. Even with the best of intentions, sometimes things go wrong. Here are a couple examples that I found very easily on the internet. This gentleman on the left-hand side is attempting to screw in something using a power drill over water on a ladder. My recommendation from a legal standpoint would be not to engage in this sort of conduct or encourage others to engage in this sort of conduct. And then in honor of Thanksgiving, here's a turkey fryer that exploded. I love fried turkey personally, but I am not frying a turkey. I'll just throw that out there. So getting back to the State Tort Claims Act, in the 1950s, the state and the legislature recognized that this is a pretty harsh rule, that the state is completely immune from any and all sort of legal recourse. So what they did was they passed the State Tort Claims Act. And what it allowed was for people to sue the state based on what they believed were negligent acts, which they could receive monetary compensation for. But because it is what's called a waiver of that immunity, that general immunity, what they did was they carved out a very, very, very narrow kind of constraint or parameters under which you can sue the state. So the basis under which you can bring a state tort claim is based on what's called tort law. Okay? And tort law is kind of the big overarching legal theory or premise. You can think about it as like you've got tort law over here, you've got constitutional law over here, you've got contract law over here, and kind of said another way, think about tortuous conduct. That's kind of another phrase used. And a tort is essentially just a legal wrong. And that is the basis, that's the legal basis under which you can bring a claim. And to split hairs even a little bit more, in order to bring a tort claim, it has to be premised on the legal theory of what's called negligence. Negligence is a big, fat, wide, open legal doctrine that you can fit a lot of different things into. Now, generally, with regard to tort litigation, which is the overall legal theory, there's basically four different kinds of torts. And again, negligence is the only one that you can bring a tort claim for. So the other ones are things like assault and battery. Okay, assault and battery is what's called an intentional tort. And again, this is not a personal, this is example, this is just a hypothetical, but let's say you go to the DMV, okay? And you're waiting in line a while and you are not happy with your customer service and you get into an argument with the DMV agent and they punch you in the face, okay? That is an intentional tort, okay? Because that person intended to hit you in the face. That's an assault. You cannot bring that claim against the state agency under the State Tort Claims Act. Another type of tort that is not covered are what are called products liability cases. So anyone ever here seen a mesothelioma commercial? Yes. If you've watched TV at any point during the daytime, you have seen a commercial for mesothelioma. Same thing with Weed Up or Roundup 5000, the weed killer stuff. Those are what are called products liability cases. You buy a product, it didn't work the way that it was supposed to, you can sue on the basis of that. The third are what are called strict liability cases, which is an inherently dangerous activity. If you own a tiger, okay, and your tiger gets out and mauls somebody, even if you bought the Super Tiger Cage 5000, it doesn't matter. You're still going to be responsible for the tiger. And just some quick free legal advice. If you own a tiger, I would encourage you to try and maybe give it to your neighbor. I don't know if they'll take it, but I generally don't encourage people to own, dangerous animals. So anyway, getting back to this idea of negligence. Negligence, the definition is failure to properly act or not act when there is a responsibility to do so. And in order to prevail on a negligence claim, the plaintiff must prove, and there's 4 basic elements. 1, that there was a duty. 2, that there was a breach of that duty. 3, that there were damages. And 4, that the damages were proximately caused by the breach of that duty. I used to be a big John Grisham fan, and then when I went to law school and started reading all these legal books, I very quickly lost my appetite for them. And then this other book here, Criminal Negligence, I just found it online. If anyone has read the book, let me know how it is. Kind of looks like a 5-cent novel, but that's neither here nor there. So here's our example of a negligence case. As you can see, somebody had a rough day and ran into somebody's house. So this is a very, very kind of easy example of how we can go through the elements of duty, breach, causation, and damages. But one thing that I want to just throw in here is, let's just assume for the sake of this hypothetical that no one was injured by the car itself, okay? But let's just say this is your house and you happen to be sitting over to the side enjoying your Thanksgiving dinner, watching the crummy Detroit Lions, and the ceiling fan falls on you, okay? So let's just keep that fact. So duty. What is the duty of the motorist here? Well, clearly the duty of the motorist is to not run into somebody's house. It's to keep their car under their control. Did this individual breach that duty? I think it's pretty clear that they did, or else they wouldn't have ended up in somebody's house. Was someone damaged? Well, yes. Both the house was damaged, and again, let's just say the ceiling fan fell, hit you on the head, and you got a concussion as a result of that. You were damaged as a result of that. One of the biggest issues that we typically deal with in these negligence cases are what's called proximate cause. And what that is there may be secondary acts that cause you damage that aren't directly related to the actual negligent act itself. So what I mean by that is this gentleman runs into the house, and it causes the ceiling fan to fall and hit you in the head, okay? That ceiling fan would not have fallen and hit you in the head but for the person running into the house. So you weren't actually hit by the car, but hitting the house created a chain of events leading to those damages. So sometimes this kind of chain gets stretched out very, very far. This legal kind of chain gets stretched out very, very far. And so it may be difficult, but this is just kind of an easy, simple example of what's called proximate cause. All right, getting back to state tort claims. State tort claims are adjudicated or heard in what's called the North Carolina Industrial Commission. If anyone is not familiar with state tort claims but has heard of the Industrial Commission before, it's probably because of a workers' compensation case. The Industrial Commission is an administrative court that was set up by the legislature, and the IC, as we affectionately call it, here's kind of different sets of cases that don't end up in general superior court. The biggest of which is workers' comp cases. I don't know this for a fact, but my guess is that probably more than 75% of the cases that are in the Industrial Commission are comp cases. And then the Industrial Commission is actually under the jurisdiction of the Insurance Commission, or I'm sorry, the Department of Insurance that got moved over a couple of years ago. The IC also hears these state tort claims, and then they also kind of hear some different random stuff like the State Eugenics Compensation Fund. They're responsible for handling that. State tort claims are filed in the Industrial Commission. Lawsuits against the individuals are filed in Superior Court, and that's just a picture of the Wake County Superior Court. It's a pretty impressive building, although they just built a brand new Justice Center. The IC these cases are heard by what are called judges, or actually more specifically they're called deputy commissioners. That's the name of them. And there's a couple of big differences between the Industrial Commission and regular superior courts. The first and kind of the biggest one, is that our cases, when they go to trial, are not heard before juries. A lot of people think that anytime you go to a trial, it's before a jury. Our cases go in front of judges specifically, and so the judges are the ones who hear the evidence and then make the rulings. And then the second is the cap on damages that can be awarded. In Superior Court, claims against an individual, there is no cap. In theory, you could receive $1 billion. In the Industrial Commission, the cap is $1 million. So that's the most they can receive. So jurisdiction. Jurisdiction over state tort claims. Jurisdiction is kind of a cultural buzzword that gets thrown around, like in cops. You don't have jurisdiction to arrest me. We're not in Wake County anymore. I'm not talking about that kind of jurisdiction. I'm talking about the court's jurisdiction when we talk about state tort claims. The IC has what's called exclusive and sole jurisdiction over these tort claims, except with one minor exception, which I'm not even going to really mention right here. And then the role of the Attorney General's office. So these are the people, and again, if you watch any television, you've seen these commercials. These are the folks who we go against. So we are defendants. We are defense counsel. That's the Attorney General's office. As it relates to state tort claims, these are plaintiff's attorneys. These are the people who represent the injured, hardworking American who just needs their justice and needs their payday. So it's very common that we see a lot of these big law firms throughout the state. Occasionally, the Attorney General's office does act as a plaintiff, so they do sue people on occasions, but not in the context of state tort claims. We do sue companies or individuals based on like Medicaid fraud or consumer protection, those sorts of things. But as it relates specifically to tort claims, our office, the AG's office in the Tort Claims Section, it only does defense work. So the types of negligence claims handled by our section, we really run the gamut of everything. Anything from the smallest property damage claims all the way up to wrongful death actions. I have personally had the pleasure of representing just about every state agency, from the prison system to Health and Human Services, to school bus cases, even some of the smaller, kind of less known agencies like the State Parole Commission, which most people have probably never even heard of. Currently I represent DOT. And if there are any DOT folks out here, I love you guys. Keep paying my salary. But again, we handle all sorts of negligence cases, and these range from, again, wrongful death claims, medical malpractice actions, engineering defects, campus security issues, toxic torts. Some of the main cases that we handle are school bus litigation. So anytime there's a school bus accident, we represent the state in that. And then we also represent the prison system when the prison system is sued by inmates, which there's quite a few of those. Again, jurisdictional limitations. We talked a little bit about some of this, about what they can and can't hear. But one of the big things that's worth noting here is that the state can only be held responsible based on this first point here, that the employee was acting within the course and scope of his employment. And so what that means, in essence, and again, I'm just going to use a complete hypothetical here, but I'm going to use DOT this time. Let's say there's a DOT employee and he's on the clock and he's driving one of those big yellow trucks that everyone has seen, and he gets in a car accident. Because he's on the clock, the agency is responsible for his actions. But let's say that he leaves work and is driving home. The minute he signs off the clock, the agency no longer becomes responsible for his actions. So if he were to get in a car accident after work, you can't sue the agency because that didn't occur within the course and scope of his employment, and that's kind of the buzzword there. This occasionally can get a little bit messy, but by and large, most of the time it's pretty clear whether or not someone is within the course and scope of their employment. Remedies afforded by the Industrial Commission. The IC can only award monetary damages. That's it. That's the only thing they can do. And the most they can award is $1 million. They can also award attorney's fees and those sorts of things. But what they can't do is order an agency or an individual to go out and affirmatively do something. And so what do I mean by that? So going back to our UPS hypothetical, our UPS situation, let's just say that case goes to trial and a jury awards Jane the driver $1 million, okay? The judge, in conjunction with ordering UPS to pay the $1 million, can also say to UPS, well, on top of you having to pay this money, we want you to put in additional training protocol for your drivers as it relates to running red lights, okay? A judge can order them to do that, and UPS will have to do that. The Industrial Commission cannot do that. They cannot order us to take any affirmative action or stop doing something. All they can do is award damages, and again, up to $1 million. That's the limit. One thing that I want to note here is that, and Melody's going to talk a little bit about this, with regard to state tort claims, all of the state tort claims, I shouldn't say all of them, but the majority of state agencies are self-insured entities. Meaning, if there is a judgment or a settlement on the part of a state agency, generally that comes out of the budget or the operating budget or wherever the money comes from, but it's from the agency itself. It's not from an insurance policy. That's the general rule. Now, for example, there are exceptions with motor vehicles. So for example, we do have a policy, the state does have a policy, which I know is going to be talked about later, with traveler's insurance for motor vehicles. But by and large, state tort claims filed in the Industrial Commission against the agency, and I want to be specific about that, that money gets paid by the agency itself. So as we talked about, the general rules of negligence apply. The Industrial Commission, aside from those nuances that I talked about, operates the same way that another state court would. The rules of evidence apply, the rules of civil procedure apply, the substantive law applies. And then a couple of things worth mentioning here. In the state of North Carolina, we have this principle that's called contributory negligence. And what that means is if a plaintiff, an individual party, is 1% responsible for the injuries that they suffered, they cannot recover. It is a very, very, very harsh rule. We are, I believe, one of 2 states in the entire country that has this rule. Most states have gone to what's called comparative negligence, wherein the adjudicator, the judge or the jury can say, well, you know, the UPS driver was 75% at fault, but Jane the driver was 25% at fault, and so that $100,000 judgment, we're going to decrease from $100,000 to $75,000. In North Carolina, if you are 1% at fault, you do not recover at all. It is a very, very harsh rule. There are some exceptions that they've put in there, but this is a very strong defense that we use on a pretty regular basis. I briefly want to mention statutes of limitations. Statute of limitations, again, is a buzzword, and what that means is you have a timeline in which to file a case. One thing that I would just note for all of y'all, if you go back and you're talking to your individual employees, lawsuits do not go away, okay? It's not something that if you get served with a lawsuit, you can stick it in a drawer and it's going to go away. Everything is time sensitive with lawsuits, and so it is imperative, it is critical, and I cannot emphasize this enough, that if a lawsuit is served on your agency or on an individual employee, you need to send that to your legal folks immediately. Because again, we have had situations where we don't know because the employee just stuck the lawsuit in a drawer, and in one particular case, we had an individual who was involved in a motor vehicle accident. She was sued in her individual capacity, so the lawsuit was actually served on her. She quit after the accident, and they showed up at her house and they sued her. She didn't do anything about it, and then they got what is called a default judgment because she did not respond. And to this day, that individual employee, ex-employee, has a $300,000 judgment pending against her that she is legally obligated to respond to. If she had told us about it, we would have taken the case and we would have represented her, but we didn't know about it. So again, time is of the essence. As it relates to statute of limitations, though, this is basically a timeline by which you have to file a case. People are always amazed about how long some of these cases take to either reach a resolution or get to trial or go through the appellate process. And a lot of times it's because people will wait until the last minute to file a lawsuit. So for normal negligence cases, it's 3 years. So today is December 4th. In theory, if you were to leave here today and get in a car accident, you could wait until December 4th, 2022 to file a lawsuit. It's a long time. With wrongful death claims, it's 2 years. They've abbreviated that. And again, that's just more of that. And then settlements. Again, another question that we frequently get is, where's a case going to go once a case gets filed? And my response to people who ask me that question is, I have no idea. It's an unappetizing answer, but it's the truth. There's 3 different ways that a case can go. A case can get dismissed before trial. A case can get settled before trial or even after trial. Or a case can go through the merits and actually be tried and potentially go up on appeal. I don't have any statistics about what percentage of cases we try versus settle versus get dismissed. But I can tell you that not in our office, but in the general public realm, in normal superior court, I want to say it's like 90% of cases get resolved prior to trial. Now, just my anecdotal evidence, I believe that we try more cases than that. I don't have any hard and fast facts on that. But we like to pursue these cases as aggressively as possible. So that is all of my time today. I'm happy to answer any questions either now or later that anyone has. But thank you for your time. And now I'm going to turn it over to Melody, who's going to be talking about cases not against the agency, but cases against the individual. Thanks.
Good morning, everybody. As Alex indicated, I am going to follow up with information that's more specific to claims against individual employees. As he indicated, the vast majority of claims involving the alleged negligent acts of state employees are filed against the actual agencies themselves under the Tort Claims Act. As Alex indicated, that doesn't mean that the claim is not based on the actions of individuals. They have to be based on the actions of individuals, or whether they're agents or employees, but it means that any judgment that is entered in connection with the act or omission is against the agency itself and not against the individual. We get that question a lot, where employees of agencies who've been sued in the IC, where the agency has been sued and they're involved, they're concerned that any judgment might be against them. It's not. If it's in the Industrial Commission, it's against the agency itself. Now, however, plaintiffs may also maintain claims against the individual state employees, and those are not limited to negligence claims. Those can be other types of causes of action. And jurisdiction over those claims, as Alex indicated, is in the general courts of justice, and that could be small claims court, district court, superior court, based on the amount of money in controversy or the type of claim. It's important to remember that sovereign immunity, it applies to the state. It does not apply to the individual. So none of us here, even though we may be state employees and even though we work with other state employees, we do not have the benefit of sovereign immunity. And we are subject to the same law and the same procedure if we are sued individually as we would be if we were sued outside of our official duties or we were involved in something on our personal time. So it's important to remember that. And as a result, there's no cap on the damages that can be awarded if there is a claim against an individual. Like Alex said, the vast majority of times we're not dealing with claims against individuals, but where we are, there are certain protections that state employees are able to take advantage of. So the Defense of State Employees Act, NC Gen Stat 143-300.3, basically provides that an employee who requests assistance with a claim may be able to get representation, and that could be criminal or civil. I don't know of ever a criminal claim in which the AG's office undertook representation, but it is available pursuant to the statute. Fortunately, I don't know of a lot of situations where our employees or former employees are subject to criminal charges, but it's one part of the statute that sets this apart from the Tort Claims Act, which is only civil, only negligence claims. This has to be brought against the employee or former employee in connection with their something that was done in the course and scope of their employment as a state employee. So for purposes of the Defense of State Employees Act, an employee is defined as officers, employees, or agents. So that's important to remember because while an officer or an employee is generally pretty easy to identify by the state agency, an agent could be a non-employee who maybe is a volunteer or someone else who doesn't have an official connection to the agency. So for example, you could have a circumstance where there's a student volunteer or someone who's just there, for the day. If they are deemed by the court, which it's a legal determination whether someone is an agent or not, but if they're deemed by the court to be acting under the direction of the state agency, they could be able to request representation under the Defense of State Employees Act. So it's important for us in each of these cases to look very carefully at the specific circumstances. Requests for representation, and this is very important, must be made in writing by the individual employee and the individual employee's supervisor. And the reasons for that are pretty clear. We would never want to have a circumstance where we are undertaking action on behalf of someone who hasn't agreed for us to represent them. We also would not want to have a circumstance where the state agency that's involved has not had an opportunity to weigh in on that and give input on their take on the circumstances and whether they believe that it's appropriate for us to undertake that type of action or representation. And the reason for that is that the state agency's money is implicated if we do undertake the actual representation. As Alex mentioned, time is absolutely of the essence in responding to a summons and complaint. Alex knows because we've had this happen before where, we find out about summons and complaint that's been served. No one knows when it was served, so we have no idea how much time we have to respond if we do undertake representation. We don't know whether it was properly served. It really is, for us, it's panic time at that point. Even though we haven't undertaken representation as an attorney, you want to make sure, and you are concerned to know, okay, is this something that we have time to respond? Do we need to get an extension of time to answer or file motions to dismiss? As Alex indicated, the circumstances, if we do not, or if the employee doesn't let us know, can be very, very harsh and very, very damaging. So default judgment could be entered, and that just basically means that there will be no trial, and that a judgment is entered based on the fact that there was no response. So that's one thing to be cognizant of, and that's why we always encourage agencies to train their employees. If you receive something like that, better safe than sorry. So if you don't know what it is, if you receive something that looks like a legal document, take it to someone at your agency. Our agencies have legal staff. If there's no one who can answer the question, they are able to contact AG staff to just find out, what is this? What does this mean? What should I do? In addition to responding to a summons and complaint timely, where there is a claim against the individual, there can be adverse impacts if discovery is not responded to on time. Most of you all, I'm sure, are familiar with the discovery process. It's a part of pretty much every civil action and even criminal actions. It works very differently in a civil context. For example, there's what's served sometimes are called requests for admission, and it's basically plaintiff sends, it can be defendant as well, but in this scenario, plaintiff sends request for admission, admit that you ran the red light and hit my vehicle. If that's not responded to within the time allotted by the rules, or if an extension is allowed by the court, it's deemed admitted. And in a context where the issue is running of a red light, or whether you ran a red light and caused injury, that's the ball game. So it's very important to realize and recognize that if you are the individually sued person, you want to be able to take some personal responsibility for making sure that you work with your attorney very closely, and your supervisors and whomever else at your agencies, to make sure that those things are responded to, and that you're able to work very closely with them on that. Now, once the Attorney General's office receives a request for representation, there are internal procedures that we follow. So again, we have basically, without an extension, 30 days from service to answer, motion to dismiss, motion for extension of time, whatever. And so obviously a lot has to happen within a short period of time. So the sooner we know that something's going on, the faster we can start that process. If the AG's office decides to undertake representation, an attorney will be assigned to the case, and if the excess carrier or other insurance policy carrier has not been notified, they will be notified of the pending claim. With claims against individuals, a lot of the time those claims are not handled by the Tort Claims Section. Sometimes they are. For instance, Alex handles a lot of those types of claims on behalf of DOT, but it's very possible that you could be assigned an attorney from elsewhere in the AG's office would be assigned to the case to work on that and be the attorney for the employee. So also, depending on the type of claim that's asserted against the individual employee, private counsel may be provided. So for example, private counsel may be retained to represent employees who are involved in claims with a motor vehicle, a state-owned motor vehicle. So the traveler's policy provides coverage for claims involving state-owned motor vehicles. Certain exclusions apply. We always have to look at the policy to determine whether or not it applies, and it would have to be something in the course and scope of the employment. For example, we've had before cases in which employees are traveling out of state, driving a state-owned motor vehicle for a conference or something like that. Travelers will contract with an attorney that's licensed in that particular state if there's litigation going on, and that attorney will handle it. So if it's a claim against the state involving a motor vehicle, the AG's office handles. If it's a claim against an individual, generally there will be an attorney that will be provided to the employee. Additionally, claims involving medical malpractice, counsel may also be provided by the medical malpractice insurance carrier. Again, always there are exclusions based on the particular policy and based on the particular facts and circumstances surrounding that. Still, if there are any types of policies that you know apply to certain claims, it's a good idea to go ahead and put people on notice and so that they can determine whether or not it falls under the policy. So where the cause of action involves negligence, a plaintiff can and very often does maintain an action in the Industrial Commission and in Superior Court against the individual employee. One of the questions that Margie and Liz indicated that a lot of people have sometimes with these is just what is the difference between a tort claim, something that's in the Industrial Commission, and a claim under the Defense of State Employees Act. And I think hopefully we are answering that question. But I think the reason that there's sometimes confusion is because often we have those claims going on simultaneously. So the employee will know there's a claim against their agency and they're a witness and they're involved in depositions and they're being asked to provide information. They're working with an attorney in the Tort Claims Section. And then they will also be individually sometimes served with a claim relating to the same set of circumstances. And so it can be confusing, but where it's based on negligence, there can be claims going on simultaneously. Now, generally, we try to get one of them stayed, and that's a determination that the court makes, but there are often still times where there will be circumstances where the same action, acts or omissions are being litigated in separate forums. Despite the fact that this is possible and plaintiffs can do this, they cannot have double recovery from the state. So basically, they are not able to recover against the state, both in the individual claim and in the claim against the IC, if it's based on the same acts or omissions. So basically, they can't get $2 million just because they decided to file in two different places. There would be a cap of $1 million that if the state undertakes representation of the individual would be available as judgment or as settlement funds in the claim against the individual, and that's the same $1 million that is available under the Tort Claims Act. And I will go a little bit more into detail on that as we go along. As I previously stated, the Attorney General determines whether or not a defense will be provided by the state. If the state refuses to defend, it does not pay the damages award. NC Gen Stat 143-300.4 sets out the grounds for refusal to defend. So a lot of people have questions about, well, what types of cases will the AG's office not defend me for? And I hate to say this, but we have to look at the statute, and it depends on the facts and circumstances. So the statute basically indicates that a defense will not be provided if the act or omission was not within the course and scope of the employment with the state. So if there's a situation where you're engaging in a criminal act, that doesn't mean that absolutely not, but that's a good red flag to there being a defense provided for you, because it's under no one's job description and course and scope of their employment to commit criminal acts. Also, if a defense will not be provided if the employee or former employee acted or failed to act because of actual fraud, corruption, or actual malice on his or her part, or defense of the action would create a conflict of interest between the state or employee, or defense of the action would not be in the best interest of the state. So those last two can be clear as mud, but that's why I say it depends on the circumstances. There are certain circumstances where there would possibly be a conflict of interest that's created, and because of the role of the Attorney General, there may be a determination that it's not appropriate for there to be representation. I do think that I want everyone to understand that it's so highly dependent upon the circumstances. And if representation, is declined, the state, as I indicated, will not pay the resulting judgment, and the excess policy will not apply. But as I indicated, it's important to remember that these determinations are made on a case-by-case basis. We represent employees in claims all the time that are filed against them individually. And we do so, that's part of the reason that we need input from the state agencies so that we can determine their position on it, because obviously if the state agency says, no, we fired this person, they stole money, they did this or they did that, then that's going to weigh onto the decision. And if the state agency says, yes, absolutely, this employee is awesome, we want you to defend them to the fullest extent that you can, that's going to weigh into the decision too. But ultimately the decision is belongs to the Attorney General per statute. So next I want to just mention the excess insurance coverage. There's an excess liability policy, which all of you are aware of, I'm sure, that provides coverage generally provides coverage for wrongful acts committed by employees in the performance of their job. It's administered by the Public Officers and Employees Liability Insurance Commission. Again, and I'll get into that, there are exclusions, and those exclusions may be created by statute, and they may be created by specific provisions in the policy itself. The excess policy is a master policy for university and state employees. The current insurer is BRIT. It covers employees, officers, agents, and volunteers, but does not include independent contractors, and that follows very closely the language of the Defense of State Employees Act, because under the Defense of State Employees Act, independent contractors are not included under, and they are specifically excluded from the definition of employee. The policy is an occurrence policy, meaning that it applies to occurrences during the policy period. So, and I'm looking at Liz for help if I mess any of this up, because often we ask for assistance in determining, okay, we have an action or something that has occurred. Sometimes it can be something that occurs one time. Sometimes it can be a continuing course, and sometimes multiple policies may apply. But we are looking at these cases in this current policy and our policy that we had before in the past few years are occurrence policies. So we would be looking at when did the alleged negligent act or omission or wrong or whatever it is occur. And that would be what we would look at to determine which policy needs to be put on notice. And that would be one of the first steps that we would take. And it's a very important step because they have to be made aware of the action at the earliest practicable time, which is, I think, the language that they've included in the policy. So the policy limits of the current policy that we've had in place since last year are $2 million for each covered employee, $2 million for each occurrence. The annual aggregate, that the maximum that can be paid for any policy year, regardless of the number of claims, is $10 million. The retention is $1 million, and that's pursuant to the Defense of State Employees Act. So that $1 million is what I mentioned earlier. That is the same cap that we would pay under the Tort Claims Act. So state agency, if you get a judgment over $1 million, the state agency pays the $1 million, and the excess up to whatever policy limits are available at that time are paid under the excess policy. Again, most important thing to remember is with anything that's contractual in nature, it is subject to the exclusions, the terms, conditions of the individual policy. So we look very carefully at that as well when we have these claims. So when we talk about who is covered by the policy, we are, again, we're looking back at the language in the Defense of State Employees Act. So we're looking at individuals who are currently employed and working for the state, if covered by the Defense of State Employees Act. A good kind of rule is if you receive a payroll check and the state withholds taxes and deductions for benefits, then chances are that's you. volunteer workers as agents of the state, other agents of the state, depending again on the circumstances. It's something that can be a gray area and can be something that has to be determined in any given case. Individuals previously employed by the state and covered by the Tort Claims Act and the policy during their period of employment with the state, and individuals employed by the university system, community colleges, or technical colleges and covered by the Tort Claims Act. And again, when we talk about what is covered by the excess policy, there are lots of different terms, conditions, exclusions in the policy, but generally occurrences which result in a claim against a state employee as provided under the Defense of State Employees Act are included unless they are excluded by the policy or by the general statutes. And when we talk about those exclude, or what would be not covered by, we look back at 300.4, 143-300.4. Again, the policy mirrors the language in the Defense of State Employees Act where it lists the provisions of what would not be covered, conditions under which the AG would not undertake representation. So again, an occurrence that's not within the course and scope of employment, an occurrence which involves fraud, corruption, or malice, an occurrence which creates a conflict of interest between the state and the employee, an occurrence for which representation would not be in the best interest of the state. And one thing to keep in mind is that although the excess policy does not apply when the AG declines representation, representation may still be provided even if the particular cause of action is excluded by the policy. So put another way is that the AG's representation is not limited by the terms of the policy. It may be that a policy does not apply, but the AG's office still can, under the statute, undertake representation pursuant to the Defense of State Employees Act. Additionally, within the policy, and this is not all of the exclusions, but certain exclusions are types of claims that involve motor vehicles. Again, we have a state motor vehicle policy, so the excess policy does not take into consideration motor vehicles. Claims arising from the rendering of or failure to render medical care, although the current policy does have an incidental medical care term that could be covered, certain types of actions could be covered. That, again, is something we would look at on a case-by-case basis. And again, other exclusions may apply depending on the facts and circumstances of the particular case. So one of the things that I always tell people is to, I think people worry a lot, and you know, it's understandable. I'm a state employee as well. I think people worry a lot about being sued in their individual capacities. I think one of the things that everyone should take into consideration is that it's rare. Number two, there are protections that have been put in place to make it as the least unpleasant that being sued can possibly be. And the fact that, you know, we have never that I know of, and I asked my supervisor who's been there for been at DOJ for 20 years, cannot recall a circumstance where representation was undertaken and there was ever a judgment left over that came from the individual employees. So if it provides any comfort, I think, you know, we've had these consistently throughout over the years, and it's a situation that is rare, and we want to keep it rare. We want for our employees not to be sued individually. We don't want that. And so where we can, we try to keep that from going any further than it has to, and we try to, if we can, to, if it's a negligence claim, keep it, you know, in the industrial commission against the state agency. And by and large, our state agencies have the same feeling, because all of us, you know, want to be able to protect our employees when they're working within the course and scope of their employment. They're doing what their employers want them to do, and obviously we want to provide protection for them. So that's all that I have. Alex, if you want to come back up just in case there are questions about your portion. We have some time for questions. If anyone has anything they'd like to ask.
Sure. What would be the difference between suing
So, and this is, again, a gray area. So essentially, yes, the question was, what is the difference between suing an employee in their individual capacity and in their official capacity? Technically, claims that are brought against the individual employee should be individual capacity claims. That doesn't, as you all know, we can say they can't do this, they can't do that. They can, and they do. I mean, they can file a claim. If there's a claim that is filed and every allegation that is made against the individual employee is clearly an official task, it's clearly something that's within the job description. So for instance, for a DOT maintenance, county maintenance engineer, if it's you went out here, you did not properly repair a pothole, or you didn't properly supervise staff who were repairing a pothole, our response to that would be to move to dismiss and say, this is not an actual individual capacity claim. This is all basically things that this person was clearly doing on behalf of the agency. And most of the time we are successful in getting that dismissed. Attorneys who are more savvy will, and it's hard for me to think of an example, but they will kind of manipulate the allegations to try to allege acts that would be individual in nature, such that they can get that additional pot of money, possibly from the excess policy. But we have been successful in Superior Court in getting claims dismissed because we're saying, you may say this is official, but this, when you look at the allegations, or you may say this is individual, when we look at the individual allegations, they're clearly official capacity. So the difference is, there is supposed to be a difference, but a lot of the time when plaintiffs file these claims in Superior Court, they don't make very much of a distinction at all between the two. Anyone else? Yes.
Independent contractors and temporary employees, is there a difference?
So independent contract. Oh yes. Is there a difference? Thank you. Between independent contractors and temporary employees in terms of whether there's coverage under the Defense of State Employees Act? Is that your question?
Yes.
So there can be. It depends on the facts and circumstances. So an independent contractor is generally someone who is making decisions on their own. They're not necessarily following the directives of the agency. And I think that in most of the circumstances that we have, a temporary employee, they do have duties. They are being directed by the actual agency. So certainly, and I can't say that in every case, but generally, if you have a situation where you have a temporary employee, it's more likely that that person, you're going to be able to say, although not an employee, a permanent employee, is acting as an agent on behalf of the agency. Anyone else? Yes.
In the case of an employee death on site, which courts does that go to if the family sues?
So an employee, the question was, if there's an employee death on site, what court does it go to if the family sues? The answer is that in a lot of those cases, if it's an employee, that's going to be a workers' compensation claim. There is such a thing as the Woodson Act, which is it's unusual for a plaintiff to be able to actually successfully make out a claim. But basically, Woodson, under those circumstances, there would have to be acts that are so egregious that it goes beyond kind of a regular workers' comp scenario, and they're able to make a claim that there should be the ability to recover in negligence as well. So we do have, unfortunately, from time to time, employee deaths that are handled by our workers' compensation section. And we have in the past had cases in which the plaintiffs have attempted to sue the agency or individual employees under a Woodson claim. Anything else? Yes, sir.
Can a state agency have a tort claim against another state agency? And if so, how do they have to agree? Can they use agreements to spell out the terms of the liability of that potential tort claim?
So the question was, can one state agency bring a tort claim against another state agency, and can they spell out agreements in terms of, I guess, resolving. Is that what you're asking, resolving the claim? The answer is that there's nothing that I'm aware of in the Tort Claims Act that would prevent one state agency from bringing a claim against another. As you can imagine, we don't have that circumstance very often. Most of the time we have, if there are things that are going on between state agencies, those are resolved between the agencies. So I do not work on those types of issues for our state agencies. So in terms of what policies or statutes there are that determine how agencies can interact with each other, I'm not able to answer that question, but I do know that they are able to generally, where there are issues, work those issues out. But if there were a situation where they did decide we can't work it out, I don't think there's anything in the law to prevent the agencies from suing each other. We have not, I've been at the AG's office for 13 years. I've never seen that. Obviously, we would not encourage that. You know, if it were to occur, obviously, it could be a circumstance where we could be conflicted out of representation because we are tasked with representing all state agencies. We have had circumstances where one plaintiff sues two state agencies, and in those circumstances, there are scenarios where in order to defend themselves, the agencies may have to, and I hate to say point the finger, but they may have to say, no, actually, this wasn't our responsibility. This was this other agency's responsibility. We have, and I have been involved in a case like that. And in that circumstance, we had different attorneys within the AG's office represent each agency against the claim by the plaintiff. So we have had that circumstance, and that's probably a more common circumstance than having the agencies just directly suing each other. Yes, sir.
I have a question about course and scope of employment. Is it possible for an employee during the day to shift in and out of their course and scope of employment? And who would measure that, and how would that be determined?
Okay. So the question was, is it possible for an employee throughout the day to shift in and out of course and scope of employment, and who would determine that? So the court would determine that if there were a legal action. Otherwise, the agencies, you know, could say, well, when you were doing this or that, we perceive that to be part of your duties, and when you went to the gas station to get gas and stopped by your mom's house on the way, we don't consider that to be. I think most agencies would not consider that to be. We have that as a fairly common circumstance, as you can imagine, particularly in workers' compensation cases. So there are often situations where it's just highly fact dependent. And we have had actually some cases go up through the appellate courts with that question. Was this course and scope or was it not? So the answer is probably clear as mud, but it does depend very much on the circumstances. There are certain situations where, you know, if you're driving home from work and something happens, generally people agree that, hey, that's not course and scope. But there could be circumstances where, you know, certain types of jobs that could be considered to be course and scope.
Separate aside from that, you mentioned if the Defense of State Employees Act request had been made in writing by the employee and the supervisor.
Yes.
Can you define supervisor? What does that mean to you?
So the question was, under the Defense of State Employees Act, I'd mentioned that the request needs to be made in writing by the employee and the supervisor, and what does that mean to me? So what it means to me doesn't matter. It's if the agency says that that's the supervisor, that is who we would want the request from. So if the agency says it's this person, this is the supervisor, because if we needed to find out who your supervisor is, we would ask you, and then we would call that person and say, you know, are you the supervisor for this person? We don't make that determination. So,
The follow-up to that is, you know, so that a lot of our agencies have very large layers of bureaucracy. Is it possible that an employee and supervisor could file for the Defense of State Employees Act without the agency even knowing about it?
I guess it's possible. The question was, is it possible within the bureaucracy of certain agencies for the employee and their supervisor to request representation under the Defense of State Employees Act without the agency knowing about it? I think that it's possible, but most of our agencies that I'm aware of have internal procedures in place for what employees are supposed to do, and keeping in mind that at some point during the litigation, things are going to go beyond those two people. I mean, there's going to be communication from our office with others at the agency. And, you know, I'm not aware of this ever having happened, thankfully, but if there was something that was done and something was misrepresented to our office in getting representation, then that would be something that we would have to address. But between the agencies having their internal reporting of incidents and the agencies having, you know, generally a pretty good line of communication with our office, I'm not aware of that occurring, thankfully, but it's certainly possible.
Yeah, and if I can just follow up
Yeah.
on that, I mean, if an individual is sued and there is a request under the state, and there's a request made pursuant to the Defense of State Employees Act, if an individual employee gets legal documents, it's generally a pretty good idea for them to bring that to the supervisor, and then the supervisor to provide that, or at least let general counsel internally at whatever agency know that they've been sued. And then the process will start about getting representation, getting all the paperwork together. But reporting, following your internal reporting procedure, make sure that your employees are aware of that. And then certainly letting your general counsel know is generally a good principle to follow.
Okay. Any others? Yes. I guess it depends. I mean, it does not create additional exposure for the independent contractor to not be covered under this, because basically that just means we would not be involved. We would not step in to be involved in that. If we were sued for something that an independent contractor did, then our defense would be, we did not have control over this person. We did not train them. We did not direct them to do what they were doing. That would be something that we would have to plead and we would have to argue to the court. And, you know, the court could do whatever they're going to do, but the law is well established in terms of independent contractors and whether or not they are considered to be agents. So it would be up to us to be able to argue to the court and convince the court that this person is in fact an independent contractor and that the decisions that they made and the things that they were carrying out were not at the direction of the agency. Yes, sir. The answer is generally for the first question. The question was, does the Defense of State Employees cover community colleges? And then secondly, does the Industrial Commission have jurisdiction? So yes, the Industrial Commission does have jurisdiction over claims against community colleges, but some of our community colleges have insurance policies. So in some cases, and it depends on the actual community college, they have insurance policies. And they are provided with counsel through that. Alex, I know you might want to speak to this. Alex has had several cases that he's represented in the Industrial Commission against community colleges. So
Yeah. So there are certain community colleges, and typically it's the bigger ones, I don't want to say which ones specifically, will have general liability policies. So if there is, let's just say it's a slip and fall on a college community campus or community college campus, the folks at the community college will reach out to the insurance carrier, and I've seen different ones. I know, for example, like Cincinnati has insured some of these community colleges, and they will provide all of the resources in terms of the attorney paying the attorneys, settlement costs, all of those sorts of things. But I'm not aware of a requirement that a community college has to carry a general liability policy. I don't think there is a requirement. And so if the community college does not carry a general liability policy, then that would fall back on the state or the State Board of Community Colleges to adjudicate or to handle that case. And I don't know who would pay the money, if that would come from the state community college fund or the individual community college fund. But it would be the responsibility of the AG's office to represent that community college and those individual employees. And it does happen, and I'd say it's probably 50-50 between when outside counsel is brought in pursuant to an insurance contract versus they say, nope, we want the AG's office to represent them.
Yes, ma'am.
We have interns oftentimes that work with like our professionals or occupational therapists, sometimes our clients as preceptors and students. In that capacity, of course, we're not paying them. Would they be considered an agent of the state?
They can be. So the question was whether or not interns and different examples of interns who are not actually employees or not paid, who are not paid, would be considered to be agents of the state for purposes of the Defense of State Employees Act and the excess policy. And the answer is that yes, they could be. Even if you have a volunteer, they could be. And again, we look at the specific circumstances. And what are they doing? Are they doing something that are they part of a program and they were told to do A, B, or C, and whatever occurred in the course and scope of them carrying out those duties? Those would be things that we would look at factually to determine whether we believe or agree that that agency law would apply. Yes, sir.
In situations where an agency has some protection because it appears that an employee committed an intentional tort outside the course and scope of their duties, do they sometimes face some exposure for a claim of negligent hiring?
Yes, the question was whether or not where there's a situation where there may be an intentional act, do the state agencies sometimes face claims for negligent hiring? Yes, absolutely. Those are some of the most common claims that we have because, so we have negligent hiring, negligent supervision, negligent retention we see quite often. So they will pivot because again, if you know that an employee has punched someone in the face, they're not going to be able to really get away with saying, yes, you encouraged this person to punch this person in the face. But what they can say is, you knew this person had a history of violence or a background of violence. This person had an instant, something that happened before they were hired that you should have seen as a red flag and should have not hired them. You didn't properly supervise such that this person was placed in a position where this could occur. Or this person has had a history of these types of incidents or incidents that have escalated and you have negligently retained them on your staff. So those are some of the most difficult cases for us to defend, and we do see those quite frequently. Yes, ma'am.
Follow up on that, background checks. I don't think our HR is allowed to do background checks.
Mm-hmm.
And if I can't, how do I deal with this?
So the question is, if the agency is not allowed to do background checks, how do they deal with a potential claim for the negligent hiring, supervision, or retention? I'm not aware of the specific rules, statutes that would determine whether a background check can be done or not. I know for DOJ, you have to answer a question about have you ever had an offense other than a traffic ticket. You have to put that on your application. What they do beyond that, I'm not entirely sure. But I would say that in those circumstances, if there is a law that prevents an agency from doing that, my instinct would be to say they met their legal duty. If the legal duty is to take these steps, but you can't go any further, then I would argue that they did not breach any duty in not doing a background check. They weren't allowed to. Now, if this person is a friend of the manager and the manager knows that this person has a criminal history and brings them in, then that would blow up that defense quite possibly. So we would look at the circumstances, but I would argue that there's no breach of a legal duty. Anyone else? I think we're a little bit over time, so I apologize for that. Anything else?
No.
Oh, yes, ma'am. Sure, absolutely. We have it on a flash drive, so can I email it to you, Brian? Or okay, we'll email it and then Brian can distribute. Thank you all so much for your time and bearing with us. I know this can be a dense and boring area. We appreciate it and appreciate the questions. Thanks again.